Hello everyone. Thank you all for attending our very first webinar from the Innovation Forum Cambridge. The Innovation Forum Cambridge is an accelerator for different types of ventures. We're supported by a global grassroots network of over 10,000 innovators who seek to translate scientific findings into better improvement for our lives. So today we will be hosting a webinar on innovation and intellectual property. And we are very fortunate to have with us two brilliant presenters. Now, without further ado, I'll let my colleagues present first Stephen and then Allie. So Stephen will be speaking first. As a side note, we have a next follow-up webinar about early stage funding opportunities, and that will be on the 4th of June, 2020 at 17 o'clock. Juliette, would you like to present Stephen?
Yeah. So I had some lectures at the Judge Business School almost a year ago with Stephen, and so that's how we met. So Stephen is a patent and trademark attorney. He works for a number of multinational companies, universities, and research organizations in the UK and elsewhere. He has a background in physics, and he handles patents in a wide range of engineering and IT fields, such as telecommunications, computer, software, and medical devices. So today he will talk about IP. He will give an overview of intellectual property, the different types that you can find, and he will give more insight into patents.
Thank you for coming along today, and thank you to IF for the opportunity to talk to you about intellectual property generally. And so I'm going to start by giving a relatively brief presentation on the aspects of intellectual property that are most relevant to small-scale businesses, fledgling businesses, and basically give an overview to sort of guide the questioning that we'll move on to. So what is intellectual property? Intellectual property is a key asset for businesses of all sizes and in all sectors. As I'm sure Allie will allude to later, IP is a key factor in underpinning pharmaceutical research and large-scale businesses in that sense. But it's also of particular value to startup companies, where it can be effectively the only real asset that a company has. And indeed, it can be the key differentiator between what's in your business and what your potential competitors are trying to develop. It's often what allows your business to be distinguished from other businesses, and it's the foundation of what you're founding your business on. Importantly, it can also be key to stopping other people, particularly other startups, but also established players, from attempting to copy your business, from attempting to replicate it, and from attempting to get into the market space that you'd hope to carve out for yourself. However, there are many, many different guises of IP. There's particular rules, particular ways in which they come into existence. And so the whole area can be quite complicated. So what I'm going to try and do in the rest of the presentation is give a brief introduction to the types of IP that can exist and how some of them come into existence, but also look a little bit more detail at the more common aspects of IP, patents, trademarks, designs and copyright, and the way in which they fit together and can be of use to a particular business. So this slide presents a wide range of IP rights, some of which hopefully most of you have heard of, like patents, like trademarks, like copyright, some which you probably haven't heard of, and some which I've never dealt with because they're so rare that they rarely come around anyway. But you can see that there are many different types of rights, and they all have a different role to play in protecting businesses and what's going on. One thing I will mention on this slide is I've included at the bottom reference to confidential information. Every business generates a degree of confidential information, or otherwise called know-how, essentially in how their business works, how their business runs, how it interacts with its customers, what it does. And to the extent that that helps the business, and it's things that competitors don't know about, that could be just a marketing mailing list, but it could also be how a particular product works, or how you tweak your piece of software in order to make it work effectively, so that it's actually usable rather than constantly having to phone your user support team. That's not something that's actually generally regarded as intellectual property, but it's an important interface with the intellectual property rights. So in broad terms, we have two types of IP rights that can exist. And I'm going to divide these into registered rights, which I'll cover on this slide, and unregistered rights, which I'll cover on the next. The main differences between registered and unregistered rights, as the name would suggest, is that for registered rights, you need to do something. To create the rights that you get, you have to do some kind of action. Typically, you file an application with an intellectual property office or a patent office in the country in which you want the right, and you request that it's granted to you. In order to obtain the right, often there is an examination process that you have to go through to prove that you're entitled to it, that you comply with the various legal requirements. Quite often, they require a fee payment to cover the administrative costs of going through that process. On the flip side, what you get from a registered right is almost always a monopoly right. And that means that it's a right that you can enforce against other people, even if they weren't aware of the fact that you had the right in the first place. And that can mean that the rights you get from registration are broader and often stronger in terms of protecting your business. Further down the road, registered rights are much easier to enforce. You don't have to prove that you have acquired the right in the way that you do for other rights, because you have a registration, and that is the evidence of the right. And examples of IP rights that are registered rights that you're probably aware of generally: patents are registered rights. You have to apply to the Patent Office for a patent. Registered trademarks, registered designs, I'll come on to talk about a little more as to what they are. Second category of rights are the opposite. They are the unregistered rights. And the fact that they're unregistered means that they typically come into effect automatically. That means you don't have to file an application, you don't have to pay a fee normally. Simply by doing something, you get a right as a result. There may be particular actions that you need to do, but this is usually something that's implicit in the subject matter being created. And the most obvious example that most people are familiar with in terms of an unregistered right is copyright. Copyright, when you create a work that's going to be protected by copyright, let's think of a painting or a book that you write, by writing it, by doing the action of recording what you're doing, whether that's the drawing on the paper, whether that's you typing into the computer and saving it, that action creates the copyright work. You don't have to do anything, you don't have to tell anyone that you've done that. Simply by doing it, you get copyright in that work. Now that's great because it means that it's not much effort on your part to get those rights. The downside to unregistered rights is that typically they only give you protection against someone copying. That means that someone has actually seen what you've done and they've produced something which is considered in law sufficiently similar to what you've done. So that's the protection that you get. There is no protection against an independent third party creating actually even an identical object or whatever's trying to be protected. So the protection that you get is much more focused, and it's only on someone who's actually seen what you're doing and is copying it to a sufficient extent. Generally, they're also more complicated and therefore harder, and therefore in some respects more costly to actually enforce them against a third party. That comes from two aspects. The first is that you will need to prove that you own a right and that it exists. And sometimes this can be something you have to do a long time after you created it, when the documentary evidence is not easily accessible. And then the second part is that you will need to prove this copying step. And very rarely do you actually obviously get direct evidence of a third party copying what you did. There are some famous examples, but generally what you're trying to prove is that someone's produced something which is very, very similar, and that the only way that they could have produced it is by copying what you did. The other aspect of unregistered rights is that in comparison to registered rights, where there is a large degree of harmonization around the world, unregistered rights typically are quite variable around the world in terms of what you have to do, what protection you get, and how long it lasts for. Examples of unregistered rights, as I've already talked about, are copyright, a quite similar right but relating to designs, which is called unregistered design rights. Trade secrets are another one, and not on the slide, the rights that you get in the goodwill associated with your brand that can be protected by passing on. So now I'm going to move on to talking a little bit more about the specific rights that we've mentioned. As before, this is intended to be a very high-level overview, so I'm not going to go deep into the detail of each of these rights, but simply to ensure everyone's sort of on the same page when we move on to the questions. So patents. Patents is probably the most well-known in the scientific community of the intellectual property rights, and these are time-limited rights. They only last for a maximum period of 20 years, and they are negative monopoly rights in a particular technology. That means that they can be used to stop other people from doing it, and that they give you the right to do it exclusively. So that's the monopoly part. It is important to note that they're negative because you don't need a patent to do something yourself. A patent is designed to give you protection against other people doing the same thing. Patents are granted for inventions, so that's new and inventive subject matter which relates to something technical. But importantly, they are protected in exchange for you providing a good disclosure of your invention to the world. So in exchange for your monopoly rights, you have to tell the rest of the world how to do it. And sometimes, particularly for startup businesses, there is a decision to be made at this point. Are you better off keeping your information, your technical information, secret and not telling anyone about it at all? Or are you better filing a patent application which will give you a monopoly right? And so even if someone comes along and independently develops it, you will get some protection, but you are going to have to tell everyone how to do it. And that's a decision that you have to make often as a startup company. Patents as a registered right require applications, and they're often subject to a relatively lengthy examination process in proving to patent offices that your invention is new and it's a non-obvious development. However, they do have good potential for excluding competition from working in the same technical area that you're in. And as an added benefit for a small business, when your business becomes profitable, there are arrangements in the UK at least which allow you to gain a substantial tax break under the patent box scheme when you make profits that relate to the invention. So what are the main uses of patents? Well, it's important to remember for patents, but also for all IP rights, these are business tools. They are there to support your business. They're not an end in themselves. They're there to allow your business to grow and to thrive and to protect it from competition. So why would you have them? The most obvious reason and the sort of fundamental reason behind the patent system is to allow you to block competitors from using the technology that you've developed, the inventions that you come up with, for up to 20 years from your filing date. This could be used in terms of protecting direct copying of the particular products that you're trying to sell or the particular method that you're offering. And indeed for that, you might be able to get a very narrow claim, and it might be a much easier process. But they could also be used to try and block and impede or delay competing products from coming on the market by covering not only exactly what you're doing yourself, but also other inventions that relate to the same concepts and the same principles that you've discovered. However, there are other ways to use patents in a business sense. One way is to raise revenue by licensing. A very obvious local example of that is ARM. ARM don't make anything themselves, but they do generate a very large amount of money by licensing their IP, both patents, but also in terms of semiconductor topographies, to other companies around the world who make them. And so it is a genuine business model to say, well, we are going to be a technology company, we're going to be an innovative technology company, but we're not necessarily going to make the technology ourselves. Other important aspects for smaller scale businesses and startups is that patents can be very useful to attract investment. There's a lot of awareness now within the investment community, certainly, about patents as a business asset and something that can be useful when you're seeking to attract investment. But they can also be used to facilitate partnerships with other companies, to arrange a sharing of technology, whilst defining quite clearly who has brought what to the table. What is important is that when you go into patenting as a small-scale company, you know why you're doing it. You know what purpose you're attempting to achieve when you file the patent in the first place. It's also worth mentioning in relation to patents that other people may have them. And so quite often you're as concerned, if not more concerned, about what rights other people have that might stop your business or might prevent you from operating your business. So you may want to exercise some caution before you start out on your business project in finding out what is out there and what is protected, what other parties have protected. So there may be a need to perform various aspects of searching in order to determine what rights other parties have, and perhaps where there are gaps that you could exploit, perhaps where particular companies are very active, and therefore you don't want to be tending into that area because that's an area of obvious interest, and that if you can steer yourself in a different direction, not only are you going to be in absolutely direct conflict with that existing company, but you potentially have your own niche in the market. When you find things that are out there, it may be necessary to redesign your product. It may be necessary to take a view on whether those rights are valid, whether they're infringed. Potentially, if it's a particularly valuable area to your business, you might need to form some sort of a challenge to the rights that exist already, or perhaps negotiate or license with the party that's already working in that space, and maybe aren't specifically interested in the niche that you're trying to operate in, and they may want to encourage your development because it's going to be complementary to their own work. Moving on now from patents, the next IP rights to consider is something called designs. In contrast to patents which protect innovation, so ideas essentially underlying technology, designs aim to protect the appearance of a product or a part of a product. So they're very much focused on aesthetics rather than function. For a technology technology business, this may be of less interest, but if you are getting to the stage where you are looking at selling a consumer product, so something that people are going to pick up, look at and buy, registered design protection can be very important. But it can also be used to protect the icon that you might use for your app, the icon that appears in the app store or in the Play Store, and can also be used to protect the look and feel of an app, or the skin that you use in your in the application that you provide. So designs can provide a very useful tool for protecting other aspects of your business that might not be protectable by patents. Next right to consider is copyright. As I've said, copyright is generally concerned with the expressive art forms. So that's literary works, artistic works, musical works. Those are the biggest categories of copyright works. Copyright, as the name suggests, and as I discussed in relation to unregistered rights, is a very long-lasting anti-copying right. I say very long-lasting because potentially your protection lasts for your life plus 70 years in a lot of countries around the world. And that's a lot longer than most other rights last. As I've discussed, it's automatic, but it is very important if you're going to rely on copyright to ensure you have good documentation in place which proves when you created something and that it was you that created it. Copyright is particularly valuable to businesses that create software code, which is considered to be a literary work, but also if you create websites, if you create any manuals for your product, if you create product descriptions, if you create instructions that go with your product, if you create advertising copy, all of this is protected by copyright. Copyright also protects the artistic form of logos and can be very important in that respect. So the final right that I'm going to consider in any detail is trademarks. Trademarks are complementary to all other aspects of IP, and they are aimed at protecting your brand and the relationship you have with your customers. Trademarks are particularly important if you have a business model that can be easily replicated by competition, because it can be the only thing that makes your customers come to you rather than to them. The example I often use in relation to this is Deliveroo. Deliveroo, I'm sure you're all familiar with. It's a very simple business model. You team up with a load of restaurants, a load of takeaways. You provide a platform that allows people to order food from those takeaways, and you arrange the delivery service, and you charge people for that. I could start up that business quite easily. Well, I was going to say tomorrow, but probably I couldn't in the current situation. But I would have a lot of difficulty actually, because Deliveroo is an established brand and people will go to Deliveroo for that service rather than to the new kid on the block that they've never heard of. And the reason they go to Deliveroo is because they've heard of Deliveroo and they've seen the bikes around town, they've seen people delivering it, and they've seen the advertising. The other aspect to trademarks is that if you've got a new business, how are customers going to find out about it? Or how are they going to remember about you once they have found out about you? The connection that they have with your business is essentially through your brand or your name, and that you want to protect that relationship and the investment that you make in obtaining and retaining those customers. If you do a pilot, if you obtain early people signing up by offering them discounts and so forth, you want to maintain that relationship, and that relationship is established by the brand that you use for that. So very briefly, towards the end, well, why should you care as a startup or as a small-scale business about IP? Failure to talk about IP can have quite a significant impact on a business and its prospects at the outset. But the flip side of that is actually that if you have your own IP, and most businesses do, if it's adequately protected, it can be a key value element for subsequent investors or subsequent partnerships. In a lot of cases, and a takeaway I would like you to get from today is that even if you don't necessarily do anything about IP, think about it. Think about what you've got, what you might have, what you might develop. Because many of the IP rights do require you to give good consideration at an early stage, and others give you benefits if you're there first. Failure to consider IP can have a significant impact on your business, and so it's something that I do want you to be thinking about. What should you be thinking about? As I said, IP is a business tool. It should always support your business plan. Think about what you're planning to do. Where is your business going to go? Part of your business plan should be about what rights you have, but also what barriers you're going to create to stop competition from coming into the market. When you go public with your business, what's going to stop either other startups or established players from coming straight into the same market that you're trying to establish? How do you distinguish yourself? Are you distinguishing yourself through technology? Are you distinguishing yourself through a great design? Are you distinguishing yourself through a great brand and a good customer relationship? Why will the IP be important to that? Will you be using it to try and create exclusivity in a particular market? Will you be trying to create barriers to entry? Will you be trying to use it as a sales driver? Are you trying to use it for branding, for customer communication and maintaining customer loyalty? And always within this, you're thinking of the cost benefit. What is my business going to gain out of it against what it's going to cost? So thank you for your time. I will hand back if I.
Great. Thank you very much, Stephen, for an amazing talk. Okay. So my colleague Marco will introduce Allie for us. Marco.
Yes, of course. I just wanted to say thank you very much, Allie, for joining us again. Allie is a UK and European patent attorney. She has over 20 years of experience in the sector, and she heads up the chemical and life sciences team in Venner and Shipley in Cambridge office. She has a degree in chemistry, and she has extensive experience in the pharmaceutical sector. She will be talking today about the advantage of having a patent for inventors coming from the pharmaceutical sector. So the stage is yours, Allie. Thank you very much.
Right, okay, great. Thank you very much for that introduction and the opportunity to speak to you today. So as Marcus said, I specialise in the pharmaceutical biotech sector, and I've been asked to talk to you about innovation and intellectual property from a pharmaceutical and a biotech perspective. So as you've already heard in the previous talk, there are various intellectual property rights, including patents, trademarks, designs, copyrights, and so on. And probably the most important of these in the pharma biotech sector are patents. So why does a pharma or biotech company want to acquire IP rights and in particular patents? There are a number of reasons, some of which are listed here. So firstly, IP rights add value to a company, and this applies to any company, be it a small startup or a big pharma company. If you are a startup, one of the first things you need to do is to raise of finance so that you can take your idea through to something that you can eventually sell a license. So the first thing you'll be using your patent, or probably the application at this stage, the first thing you'll be using that for is to attract investment or finance. Then, once a startup company has progressed its invention and obtained proof of concept and phase 1 clinical trials, and maybe even phase 2 clinical trial results, it is then usually time to exit, because phase 3 clinical trial results are very expensive. So the startup at that point in time will usually either license or sell its patents to Big Pharma. And Big Pharma will then develop the product further. And once Big Pharma has obtained marketing approval for a new product, they will then use the patents to exclude competing products from the market. And if you think about just how much it costs to develop a prescription drug, so the current estimate according to Tufts is $2.6 billion US. You can see how absolutely vital patents are for this industry sector. If your patent doesn't just cover a specific product, but say a platform technology, then you may be able to use your patent to exclude competitors from a whole technology area. Patents can also provide leverage. You can use them to get your competitors to the negotiating table for cross-licensing purposes. And lastly, in 2013, as Stephen had already alluded to, the UK government introduced the so-called patent box regime. And under this regime, companies can pay a reduced rate of corporation tax for profits made from products which are covered by certain patents. And when Glaxo, for example, moved its headquarters to the UK in 2013, the patent box was cited as one of the reasons for moving to the UK. And here's a graph showing just how the importance of intangible assets, such as patents, has grown over the last 40 years. From 17% in 1975 to 84% 40 years later in 2015. So right, patents, then what are patents? Of course, a lot of this was already covered in the earlier talk, but we need to recap a little bit with a slant on life sciences here. So patents protect technical inventions. An invention can relate to a product or a process or a use. An invention must be new and non-obvious for it to be patentable. Patent is an exclusive right, allowing the owner to prevent third parties from doing certain activities relating to the patented invention. So, for example, for a patented product, you can prevent the making, using, selling, offering for sale, importing, or keeping of the product. And for a patented process, you can prevent the using or offering for use of that product. As Stephen said, for infringement to be found, you do not require copying, so that if someone independently comes up with the same invention later, they will still be prohibited from using your invention if your invention is patented. patents are obtained via an application process, which we will discuss in a little bit more detail later. Patents can last for 20 years from filing, and actually in the pharmaceutical and biotech space, supplementary protection certificates and other forms of patent term extension are available in many countries, which can extend the protection for products for longer than 20 years if the products were delayed coming onto the market because of the regulatory process. And then patents are territorial. So if you want protection here in the UK, you'll need a UK patent. But if you want also protection in, say, the US, you will also need a US patent. What are the requirements for an invention to be patentable? So firstly, an invention must be new at the filing date of the patent application. This means that the invention must not have been made available to the public in any way, in any language, at any time, anywhere by anyone. And there are many potentially novelty destroying disclosures, such as academic papers, PhD theses, discussions, conference presentations and posters, any publication on the internet, sale of a product, the non-confidential use of a product, and so on. All of these are disclosures, and if they disclose your invention is no longer new, and you can then not obtain a patent. There's one exception to this, in that there are some limited grace periods available in some countries, but not in all countries. And these grace periods exclude disclosures by the inventor, him or herself, from being novelty destroying. Actually, some people had submitted questions before this talk, and one of them was whether you need any academic papers before you can apply for a patent. And the answer is quite to the contrary. You must not have any papers at all, because if you do, your invention is no longer new and then can no longer be patented. The second requirement for an invention to be patentable is that the invention must be non-obvious over the prior art. And the prior art is everything made that was in the public domain before the patent application was filed. It's often fairly clear what is and what isn't novel, but that's not the case with inventive step. Whether something is obvious or non-obvious is far more arguable. And here's a list of some arguments that are often used to support an inventive step when you need to justify the grant of a patent to the patent office in the examination process. So for example, you can argue that it has an unexpected advantage, or it solves a technical problem, it has an unexpected or surprising result, or it's not obvious to try in view of the prior art, or it can overcome a particular technical problem. All of these arguments, which are often used to support an inventive step. There are three more requirements for patentability. The third one is that the invention must be capable of being applied in industry. This is not generally an issue for pharma patent applications, but it can be for biotech applications. So for example, you can't simply claim a sequence listing in your patent application. You must disclose and describe in your patent application what the sequence does and what it can be used for. The last two requirements have more to do with the way the patent application is drafted rather than the invention per se. So the fourth requirement is that patent application needs to be sufficiently detailed so that a skilled person in the art can repeat the invention. For this to be the case, you need to include sufficient details of, for example, all non-routine techniques used, and this applies particularly to biotech inventions. If you're looking at a new pharmaceutical compound, you must make sure that you include enough evidence to show that the claimed compounds have the activity you say they have. And then the last requirement for patentability is that the claimed invention must be supported in the patent application. And that means that you need to include enough examples and vary enough examples to justify the breadth of claims. Now, actually, one of the questions someone has already asked is whether clinical trials are necessary before you can apply for a patent application. And in 99% of cases, the answer is no, you do not need clinical trials before you can apply for a patent. What you do need to show is that it's very likely that your invention would work. So if your invention is a new pharmaceutical compound, you need to show that your compound has an activity that is linked to the disease you're claiming to treat. This evidence can be in the form of in vitro assays, or even better, if you've got if you've got evidence that your compound works in an in vivo disease model. If you're looking at the biotech space, if you wanted to patent a vaccine, for example, of course a very hot topic at the moment, then say mouse model that shows that your vaccine produces an antibody response in mice would be perfectly fine evidence for a patent application. So how do you go about obtaining a patent application and a granted patent? The most important thing is that you must not disclose the invention to anyone who's not under an obligation of confidentiality, because otherwise the invention is no longer new and therefore no longer patentable. To start with, you can carry out a preliminary search yourself to see if your invention is novel and inventive over any prior art that you can find. It's a good idea to write down some notes on your invention and then discuss it with your patent attorney. And the patent attorney will then write or draft the patent application and file the patent application for you at a patent office, for example, the UK Patent Office. And this diagram shows you how your patent application progresses to grant. So once a patent application is filed, the patent office will carry out a prior art search. That usually takes about 3 to 6 months. Once you got those search results, you can then look at those and get a better idea of whether your invention is novel and inventive, and therefore whether it is likely that you'll be able to obtain a granted patent. You'll have up to 12 months, the so-called priority year, to decide whether to file patent applications in other countries. Then 18 months, so a year and a half after the initial filing, your patent application will be published. If on the basis of the search you've decided not to proceed, you can withdraw your patent application before publication, so that your invention is not disclosed if you do not want it to. If you do proceed, once it's published, the patent office will examine whether your patent application fulfills all the requirements of patentability. And then if that is the case, then eventually a patent will be granted. The examination process is also called prosecution, and it usually involves the patent office issuing examination reports which raise objections against your patent application, and your patent attorney respond to these examination reports with arguments and possibly with claim amendments. So after all this toing and froing, the patent usually will be granted roughly after 2 to 5 years after the initial filing. Now, if you do decide at 12 months after the initial filing, so the end of the priority year, that you do want to obtain patent protection in other countries, which if you're looking at a pharma or biotech invention, you would usually do, then this is what you would need to do to obtain patents in other countries. Within the priority year, you would file either an international patent application at the International Bureau of WIPO, so that's the World Intellectual Property Organization, or you'd file national patent applications at the patent offices in other countries. An international patent application is eventually entered into the national phase after 2.5 years after the initial filing, so 30 months after the initial filing, and it is converted into national patent applications at the patent offices in the other countries. So effectively, filing an international patent application delays the need to apply in other countries and simplifies the whole procedure. If you do file other patent applications at 12 months, you can reuse the initial patent application that was filed in the first place, usually UK, but you can add new information to it if you have. So if you carried out more experiments during your priority year, you can add further examples or further evidence to show that your compounds do whatever it is that you claim that they do. So, as I said, if you're working in the pharma and biotech space, you're likely to want patent protection in a number of countries. So here's what a typical filing strategy would look like. You file a UK priority application at day 0. At the end of the priority year, you will file an international patent application, and this is then searched. And if you want to, you can also have it examined during the international phase. And then the international application is published after 18 months, so a year and a half from the priority date. And at 30 months or 2.5 years after the priority date, the international patent application is then entered into the national phase in the countries you're interested in and converted into national patent applications. So you'd go into the US and Europe and maybe also China and Japan, depending on how big your budget is, other countries. Another question that someone had already asked me before this talk is whether the patent application process has been speeded up at all post-COVID, in the same way that other processes have been speeded up, such as the peer review of papers, for example. And the patent offices in some countries have indicated that they will accelerate patent applications relating to combating COVID-19, such as Brazil and Peru. But none of the major patent offices, like the US Patent and Trademark Office or the European Patent Office, have done this. The reason is presumably because there are already ways in which you can speed up the grant of your patent application. For example, you can file national patent applications instead of going via the international route, or if you do go via the international route, you can enter the national phase early. You do not have to wait for the 30-month deadline. You can request early publication. You can have your patent application examined under what's called the PPH initiative, the Patent Prosecution Highway. This is a collection of agreements between certain patent offices that they will use each other's work products, so that if you have obtained a first patent in by a first patent office, you can then take that patent to a second patent office, and the second patent office will look at the first work product, and this will hopefully lead to a faster grant in the second country. You can also request accelerated prosecution before many patent offices, including the major ones such as the USPTO and the EPO. The US Patent and Trademark Office has a process called Track 1, and the EPO has a process called PACE for accelerating patent prosecution to grant. So on average, it takes 3 to 5 years from initial filing to grant, but you can speed this up if you want to 2 years or less. In some cases, you can have it in less than 2 years. And of course, you don't need to actually have a granted patent in hand to be able to put a drug or a vaccine on the market, because although you can't sue for patent infringement until you have a granted patent, there is provisional protection provided by a published pending patent application, which means that once the patent is granted, you could sue retrospectively for the period from publication of the pending patent application. So even though the patent process is relatively slow, what usually holds up the product coming onto the market are clinical trials and the regulatory process, not the patent process. I thought it might also be useful to look at what a typical patent application in the pharma biotech space looks like. So patent application has distinct parts to it. There's a description, which includes all of your examples, patent claims, figures or drawings, and an abstract. The claims are the most important part because they define the scope of your protection. In the pharmaceutical biotech space, there are certain claims that you would expect to see in a patent application. So first, the product claims, such as if you're talking about a small molecule, then you'd see a compound or a solvate product or isomer thereof claimed. If you're talking about the biotech space, you might see a claim to a gene construct. And alongside those, you then also see a composition claim to a composition comprising the compound or the gene construct. You'd also expect to see process claims, such as a claim to a method of preparing the compound or gene construct, and you would also be allowed methods of in vitro diagnosis. Some patent offices, like for example the US Patent and Trademark Office, they also would allow a method of treating or preventing a disease claims, but those claims are not allowed in all countries. So for example, they would not be allowed before the European Patent Office. Before the European Patent Office, instead of such method of treating or preventing claims, you would have a claim to a compound or gene construct for use in therapy or for use in treating a specific disease. It's also worth looking at inventorship and ownership of patent applications. The inventor is the person who comes up with the invention, so the deviser of the invention. Who the owner of the invention is depends on the relationship of the inventor with other parties. In the UK, the default position is that the employer, in most circumstances, automatically owns an invention made by an employee. But that ownership can be varied by contract. And this is particularly important in the pharmaceutical biotech space because a lot of inventions are made at universities or in startups. So the inventor is not necessarily an employee. So if an invention is made at a university by a student or a professor, you need to look carefully at the university's rules to see who owns the invention. If an invention is made at a startup, you need to look carefully at whether the invention was made by an employee of the startup, or actually whether the invention was made by a CRO or a contractor or a consultant, and what the agreement between the startup and the contractor or consultant says about the ownership of the IP. A startup might also have received funding, and therefore the funding body may have a claim to the ownership of an invention depending on the funding agreement. Last issue I'd like to look at is freedom to operate. So a common misconception is that a patent gives you the right to carry out your invention. In other words, that patent gives you freedom to operate, and that is not the case. A patent does not give you the right to carry out your invention. What it does do is it gives you the right to prevent third parties from carrying out your invention. So your patent has an effect on what third parties can do. In other words, your patent has an effect on the freedom to operate of third parties. So on the flip side, patents owned by third parties will have an effect on what you can do. So in other words, third-party patents affect your freedom to operate. To establish whether you have freedom to operate, you need to look at relevant third-party patents and patent applications. Once you've identified them, you need to check whether they are in force, where they are in force, what scope of protection they provide, and whether they're valid. And only when you've figured all of that out can you assess whether you do or you do not have freedom to operate. If you find that you do not have freedom to operate, you might need to take a license, and this can often be easier to negotiate if you can offer a license to your invention in return, i.e. if you can enter into a cross-license agreement. So to recap, for a good IP strategy, you need to be aware of IP, and you need to make sure that everyone else in your organization is also aware of IP. You need to identify your IP and establish what your commercially relevant IP is. You need to establish whether that is patentable or otherwise registrable. You need to establish who owns the IP. And in fact, it pays to do this before any IP is created at all. And bear this in mind when you enter into agreements with universities, contractors, consultants, funding bodies, and so on. Who's going to own any IP before it's created. You need to take steps to protect your IP. You need to carefully consider where to protect your IP. You need to consider how you will use your IP. So are you a startup that needs funding and an exit strategy, or are you going to take your idea all the way to market and you need to keep competitors at market? And lastly, you need to make sure that you have freedom to operate and you do not infringe any third-party IP. So I'm happy to take any questions, but I'll hand you back to the IF team.
That's all for today's talk, today's webinar on innovation and intellectual property. Thanks again for everyone for attending. Thanks again to Allie and Stephen for your absolutely very amazing talks. Just wanted to quickly remind that we have our next webinar is about early stage funding opportunity, and it will be in June. We will send the Eventbrite link in due time. Yeah. So thank you everyone for attending.